My name is Bob Bennett, and I've been given the task of introducing this program. I have no idea why we need an introducer for the program since we also have a moderator. Uh, so I'm going to conceive my job as telling you who our stars are over here, all three of them, and then getting out of the way as quickly as is seemly. Um, the program is a debate about the constitutionality of the so-called individual mandate of the health care legislation that was passed a number of months ago. Uh, as far as I can tell, this question of the constitutionality has attracted enormous attention around the country, including from academics, and that attention is distinguished by certitude on both sides, which is almost unprecedented. Without further ado, I will therefore introduce, pardon me? With litigation too, there's no doubt about it. We in the academic world tend to think that the academic action is the real action, but you're quite right. There is litigation about it too. So our debaters today are Professor Martin Redish, who's to my immediate right, who will, as I understand it, defend the constitutionality or argue for the constitutionality of the individual mandate, and Professor Presser to my far right over there, who will take the contrary position. All this is to be moderated by Andrew Koppelman, who sits in the middle of these two, undoubtedly, to keep them from engaging in violence. Andy?
What else is there to say? I would now introduce Marty, except that's already been done.
Am I okay here? It is great to see all the alums out here. And I've got to say, not one of you looks a day older than the day you graduated. But then my eyesight's going, so you're sort of more of a blur than anything else. I want to start with a disclaimer. And that disclaimer is that, as you will quickly recognize, Steve is much more proficient than I am technologically. So I have no doubt that the East German judge will give him many style points for his technological success. I can only hope to make it up in substance. I've titled my talk, Asking the Right Questions, because what I've found quite puzzling to me here is that the conservatives manage to ask all the wrong questions, answer them, and then find the law unconstitutional. As we will see later in my talk, not one of those questions has the slightest relevance to the actual constitutional issues. So what I want to do today is steer the debate to what the actual correct questions are. And once we understand what those questions are, we'll see there really isn't the slightest doubt about constitutionality. If we put ideology outside of the scope of the constitutional inquiry and actually do it from a principled perspective, there really is no doubt that this individual mandate is constitutional. What I'm going to do today is first to set out the broad constitutional framework, the structure of the Constitution, the constitutional ether in which all of these issues are examined. Secondly, I'm going to apply that framework to the individual mandate to show how the individual mandate fits like a glove with the law as it exists as of now. And finally, I'm going to expose what I consider the really phony so-called constitutional issues that the conservatives have tried to put up there as their smoke and mirrors to find this law unconstitutional. First, the constitutional framework. The first thing to realize about the Constitution is that it is a counter-majoritarian document. It is a limitation on the majoritarian branches of government. It is interpreted and enforced by a branch of government that is completely insulated from political pressures, from political representation, from political accountability. As a result, the judicial branch, in interpreting and enforcing the Constitution, has to have an appropriate degree of humility. We start with a majoritarian presumption. The judges who are unaccountable and unrepresentative are not allowed to simply supplant the existing views of the majoritarian branches with their own. They have to be able to ground a finding of unconstitutionality in a specific provision or structural framework in the Constitution, or otherwise they degenerate into Platonic philosopher kings and basically undermine the entire democratic nature of our system. Okay, to understand how laws can be unconstitutional, we can set up two different categories of inquiry. The first I call the checklist inquiry. The second I call the enclave inquiry. The federal government, first, is a government of limited and enumerated powers. Every time the federal government acts, it has to be able to ground the exercise of that power in a specific grant of authority. I refer to this as the checklist. If a branch of the federal government acts without being able to ground that action in one of the enumerated powers, we go home. It's unconstitutional. This is especially true for Congress, who primarily, though not exclusively, is given a laundry list of powers in Article 1, Section 8, 17 different enumerated powers. And every time Congress acts, it has to be able to ground that action in one of those powers or one of the few other powers granted in other provisions. However, just because something falls within the checklist doesn't mean it's automatically constitutional. You then have to look at the enclaves that are set up in the Constitution, the barriers, the insulations of certain form of liberties which render something unconstitutional even if it falls within the checklist. But these liberties are not some generic protection of liberty. They are protections of specific grants of behavioral autonomy to individuals, lest the Constitution, again, consume basic democratic choices. Clearly the most important, domestically speaking, if nothing else, of the Article 1, Section 8 powers is the power in Clause 3. The congressional power to regulate commerce among the several states. Congress is permitted to regulate the transportation, the transfer over state lines of commercial services or products, and that is one of the key powers that the framers granted to Congress. But equally important, in addition to Clause 3 or any of the 17 clauses that are there, is the power in Clause 18, the necessary and proper clause. The congressional power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. This is an extremely important power because it was one of the absence of this that drove the framers to create the Constitution. In the Articles of Confederation, there was no necessary and proper clause. And it was the intent of the framers to give the federal government in general and Congress in particular some flexibility in enforcing and exercising its powers. And that's why they put that clause in. So it's extremely important to understand what this clause does. What this clause does is authorize Congress to enact laws which don't fall anywhere on the checklist if they facilitate the implementation of one of those enumerated powers, if they help get Congress from point B to point C. We don't test a law under the necessary and proper clause by asking, does it regulate interstate commerce or does it fall within any of the other powers? We ask only, does it facilitate the regulation of interstate commerce? This clause has been interpreted broadly since the creation of the nation. Chief Justice John Marshall in McCulloch versus Maryland, one of his many hits as a Supreme Court justice, wrote, "Let the end be legitimate. Let it be within the scope of the Constitution," meaning does the power that Congress is trying to exercise fall within one of the enumerated powers, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, are constitutional. As recently as 2004, the Supreme Court said that the question under the Necessary and Proper Clause is whether the statute constitutes a means that is rationally related to the implementation of a constitutionally enumerated power. Anyone involved in constitutional law knows that the words rationally related are code words for an enormous amount of deference. If there is any reasonable possibility that the law passed by Congress will get Congress to its goal of exercising one of the enumerated powers, then Congress is deferred to. As recently as last year, the Supreme Court said that the Necessary and Proper Clause gives broad power to Congress to enact laws that are convenient or useful to the implementation of one of the enumerated powers. It has consistently been interpreted in an extremely broad and deferential manner. Let's talk about a couple of the key examples so we can understand how the power has been used. In the middle of the Depression, Congress decided that the price of wheat was depressed. They wanted to raise it. How do you raise the price of something? Economics 101. You decrease the supply, you increase the demand, or both. Congress decided to do both with the Agricultural Adjustment Act. Congress limited how much wheat farmers could sell into the wheat market, thereby limiting the supply. But they also sought to increase the demand. What they did was limit the amount of homegrown wheat that a farmer could consume with his own family or his stock. In that way, they were trying to increase the demand to push up the price. Mr. Filburn was a farmer in the state of Ohio. He violated the regulation imposed on him. And he says to the Supreme Court, Your Honors, I have never even been to Indiana. I am from Ohio. Nothing I consume on my farm has ever extended beyond Ohio. And the Supreme Court said, yes, you're just a poor farmer, nobody. That was almost Justice Jackson's words. But he says there are a lot of you nobodies. And when you add them all up, it impacts interstate commerce. So think how far the court has stretched the Necessary and Proper Clause. How much wheat an Ohio farmer consumed on his own farm impacted interstate commerce. Much more recently, 2005, the Supreme Court dealt with the constitutionality of a prosecution of two sad, elderly, sick women who had been prescribed marijuana for medicinal purposes in California. Now, these two women, knowing that California marijuana is far better than even the German or French versions, decided to grow their own in their backyards. They grew California marijuana, they smoked marijuana in California, and they got high in California. I just have visions of the federal SWAT team coming down and arresting them for violation of the federal drug law because it was a crime to use marijuana that had traveled into interstate commerce. These two women first tried to distinguish the Wickard case by saying that smoking wheat is not nearly as much fun as smoking marijuana. The court rejected that suggested distinction, but the court said even growing your own marijuana and smoking it has an impact on the interstate market. This is 2005. Many of the same justices who are on the court today, including Kennedy and Scalia, held this law constitutional as applied to those individuals. Now, are there any limits to the Necessary and Proper Clause? Yes, of course there are. Because if the Necessary and Proper Clause would allow Congress to do anything, then the whole concept of enumerated powers would be meaningless. And Chief Justice Marshall himself said the concept of enumeration presupposes something not enumerated. So in two controversial decisions that I happen to agree with, most constitutional liberals do not, United States versus Lopez in 1995 and United States versus Morrison, the court drew a line. Lopez dealt with a federal statute that made it a crime to possess a gun in a school zone. An individual was arrested under this law, and apparently, despite his carrying a gun in the school zone, he had learned enough to know that there was an interstate commerce limit on Congress's power, and he says, my having a gun in this school zone in Texas has no impact on interstate commerce. And in front of the Supreme Court, the Solicitor General is asked, how does this law impact interstate commerce? And the Solicitor General replies, having guns in school zones can interfere with education. He didn't elaborate. I assume what he meant was because of the guns going off, you can't really hear something like, who did he say was the father of our country? That gun was going off. I couldn't hear. And as a result, people wouldn't be as educated. People who aren't as educated earn less. It affects the gross national product. And the court says to him, is that all you got? Well, a dead giveaway was he said, no, I have slides of my family trip to the Wisconsin Dells. Would you like to see that? And the court didn't buy that. And they said, if this is interstate commerce, everything is interstate commerce. And they struck the law down because the connection between the regulation and interstate commerce was too remote. In 2000, the Supreme Court deals with the Violence Against Women Act. And again, the court says, how does this affect interstate commerce? And again, the Solicitor General, not having learned his lesson, says, well, if women are beaten up, they won't go downtown, they won't shop at Bloomingdale's or Macy's, that'll affect interstate commerce. And the court says, we're not buying it. And both of those decisions were right. There are limits on the necessary and proper clause. It can't include everything. When the connection is remote or tenuous or far away, then the court will rightly strike it down. But there aren't that many of those situations. Now let's apply this constitutional framework to the individual mandate. First, let's talk about Obamacare as a regulation of interstate commerce. Steve has informed me that liberals don't call it Obamacare, only conservatives do. I replied that, unlike conservatives, we don't get talking points memos, so I wasn't aware of this. To regulate the national health insurance market is paradigmatic interstate commerce. You may not like how Congress is regulating the interstate health insurance market. God bless, knock yourself out, win an election next time. It doesn't mean it's unconstitutional. Now, what are the purposes of Obamacare? Well, one, they want to spread and reduce the costs of health insurance for the poor and the uninsurable. Seems like a reasonable kind of thing, unless maybe you're Ron Paul and you want them to die in the streets. Otherwise, it seems like a good thing. Secondly, they want to avoid the inefficiencies of the current health insurance system. People who don't have coverage still get medical care in the emergency rooms at an absurdly inefficiently high price, which is then spread around and everybody else pays for it. So those were the goals of what is unambiguously a regulation of interstate commerce. Now, how does the individual mandate fit here? The individual mandate requires everyone to purchase their own health insurance, and as a and if they do not, they will be fined, or a penalty will be imposed by the IRS. Now, is this useful or convenient for implementing Obamacare? No. It's essential. If you could not spread the cost of Obamacare beyond the old and the sick to the young and the healthy, the costs would be preposterous. The system couldn't work. Having the individual mandate is outcome determinative for the success of this program. Again, remember, it is not the role of the courts to judge whether this is a good idea or a bad idea. The point is regulating the health insurance market, providing universal health insurance is clearly interstate commerce. The individual mandate is completely outcome determinative. I should be able to sit down now. That should be the end of the inquiry. We can go home and watch the playoffs, but it doesn't quite work that way. Because my friend Steve says, well, what would the framers say about Obamacare? The first thing they would say is, how the heck did that guy Obama get to be president? But secondly, I'll tell you honestly, I don't care what the framers would say. Did you see the way they dressed? But if I were to suspend disbelief and say something really matters about what the framers wanted to do, I would tell you that it is by no means clear that they believed in states' rights. Some of the leading framers, Washington, Marshall, Hamilton, had played key roles in the military during the Revolutionary War, and they discovered that they were not getting money from the Continental Congress for uniforms or gunpowder or food or shoes. And the reason they weren't was that individual states were refusing to meet their allotment, and the Continental Congress had absolutely no way to enforce that. And it was that point that Marshall, Washington, and Hamilton, three of the heroes of the American Revolution, recognized we need a stronger federal government. When the very first bill to create the Bank of the United States was proposed, there was a question raised, does Congress have the power to do this? And Washington went to his Secretary of the Treasury, Hamilton, and said, are you willing to draft a memo about the constitutionality of this? And Hamilton's response was, I'll take a shot, not realizing how prophetic that statement was going to turn out to be for him. And he prepared a 38-page memo that described how broadly and flexibly the Constitution had to be drafted. So we cannot simply invoke, like open sesame. The framers would have wanted a narrow scope of federal power. The mistake is to view the framers as some monolithic unit, sort of like a 1980s singing group, the Backstreet Boys, the framers. There were actually framers who had very differing views, but the ones in power early in the history of the nation were Federalists who believed in very strong federal government, if I cared. Now, let's talk about the great arguments that have been amassed that the 11th Circuit, without its face apparently turning red, was able to make. I'm proud to say that a classmate of mine, Stan Marcus, was the dissenting judge in the 11th Circuit, and he obviously had learned well at law school because it was a brilliant dissent. The thing we have to understand here is we're all adults. We know what's going on here. The very same conservatives who are crying crocodile tears about constitutional federalism and states' rights, do you know what they're doing at this very moment as we speak? They are pushing in Congress tort reform laws to federalize the entire law of products liability, because there are some states that are too hard on corporations. Products liability has historically always been handled by the states, yet somehow it doesn't bother the conservatives to undermine states' rights when it suits them politically. Like Woodrow Wilson, they're making the world safe for hypocrisy. Phony issue number one, interpreting the wrong clause. I hear very intelligent conservatives saying, when people have chosen not to enter the health insurance market, they have not entered into commerce. Therefore, it is not interstate commerce. And I'd say that's great, except we're not interpreting the interstate commerce clause. We're interpreting the necessary and proper clause. That doesn't have to be either commerce or interstate. All it has to do is facilitate something that is interstate commerce. So they're asking the wrong question. I guess they really enjoy the answer, but it's got nothing to do with what the constitutional question is. Phony issue two, the individual mandate is an invasion of individual liberty. Well, first of all, this really isn't a question about the checklist. This is an argument that there's some enclave of individual liberty. I'm not sure where that enclave is that says the government can't make people buy something. I guess we have a freedom to have the government not have power to make us buy something. They only have power to tax us, to draft us, to take our property, to imprison us, and to execute us, but not to make us buy something. Remember, there's no generic protection of liberty. Tell me which provision of the Constitution is being violated, and I can debate it. But, of course, there really isn't any. Phony issue three, the active-passive dichotomy. Oh, this is a great one. The way Gonzalez and Wickard are distinguished is that those involved a regulation of active behavior, somebody growing wheat, somebody growing marijuana. In contrast, the people who are made to buy insurance are completely passive. They aren't doing anything, and I say, yeah, and so some of you may remember when I used to use the red bottle, green bottle distinction. Imagine a red soda bottle explodes and the soda bottle company is held strictly liable. The next case, a green soda bottle explodes and the lawyer for the bottling company says, well, Your Honor, this is a completely different case. That was a red soda bottle. This is a green one. That is a distinction, but it's not a distinction that makes any difference. I defy any conservative to tell me why the active-passive dichotomy has anything to do with whether the individual mandate is necessary and proper to the implementation of the particular power. Phony issue 4, the unprecedented nature of the individual mandate. It was amazing to me. The 11th Circuit majority opinion spent about 6 pages, maybe it was even more, talking about how unprecedented it was to have people buy insurance. And again, I say, yeah, and do you think it was precedented to tell a farmer how much wheat he could consume on his own farm? No, but so what? That's a purely political issue. And that's why none of this has anything to do with whether this is necessary and proper to the exercise of interstate commerce. I want to close with a quick story. It involves Steve. I've told it before, so I think Steve has no objection. I actually put it in print, so it involves a book I wrote a number of years ago called Money Talks, where I made a vigorous defense of the free speech rights of corporations and commercial advertisers. And I gave an inscribed copy to Steve. And he sends me an email back, and I thought it would be, oh, well, thank you so much for the best of luck with. It was one line. It said, Redish, : I always knew you were a closet Republican. Now, the only Republican I would have ever voted for is Abraham Lincoln. I headed Students for Woodrow Wilson 50 years after his death. So I am no Republican, closeted or otherwise. But I wanted to give Steve a lesson in the importance of neutrality in constitutional analysis. So I wrote him a message back. I said, the fact that I defend the free speech rights of corporations and commercial advertisers no more means I'm a Republican than the fact that people defended the free speech rights of communists in the 1940s and 1950s meant that they were communists. I get back one line saying, weren't they? I have never had the nerve to ask Steve, was that a joke? But it underscores to me that how vital, how seductive it is to let your ideology take over. I am sure Justice Thomas is outraged by this law. I am sure Justice Thomas's wife is even more outraged by it. And I hear the Tea Party has a proposed constitutional amendment to allow her to vote in Supreme Court decisions. But that's not the point. What we need is the judicial humility that conservatives usually call for when it happens to suit their political needs. Thank you.
Well, gosh. That's obviously a very, very tough act to follow. And I would like very much to be able to say to you what I think it was Mary McCarthy's political element. And that is, every word she wrote was a lie, up to and including the and. But I can't say that because Marty didn't lie. And indeed, I agreed with a whole lot of things that Marty had to say. It's a treat to be here with you, and it's a special treat to welcome back the Northwestern alumni. That's the official old seal, before we did this modern icky stuff with Adams. That's St. Ives, ostensibly dispensing justice equally to rich and poor, although it is true that the rich guy comes off a little bit better. There may be a moral there as well. So we're going to talk about the Constitution and we're going to talk about the individual mandate. And I want to indicate one broad area of disagreement with Marty, and then we'll go into some of the somewhat narrower areas. And that is, Marty's basic point was, and I like the way he put it because it was so beautifully clear, and that's one thing I've always admired about Marty is his clarity. He asked, the question here is, should we apply the necessary and proper clause? And the only question is, does this particular measure facilitate the regulation of interstate commerce? If you read the 11th Circuit opinion, you'll find a very, very good response to that. And that response is, you can't get away from trying to figure out what's interstate commerce and what isn't. Because if this isn't interstate commerce, then to allow it to be regulated, to allow this provision to go forward, would be the same thing as saying, well, we could dispense with the Fourth Amendment and have illegal searches and seizures, or we could dispense with the privilege of self-incrimination or do anything else. It's more about, I think, interstate commerce than the necessary and proper clause. But let me lay a little bit more groundwork, okay? Let me distinguish the presentation that I'm going to give from the one that Marty gave, and it's not just the pictures, okay? Let's talk about Marty. He is, in fact, one of my oldest and dearest friends, and I have absolutely boundless admiration for that. It's true, I do think he's a closet Republican, and we talked both to Forbes magazine, and that now appears in print. Marty is a very serious constitutional scholar, and probably the most intellectually honest guy I know, and he gave you a very, very good, carefully thought out constitutional presentation. I think Marty is terrific. I think if that man had any sense, he would have appointed Marty to the court already, instead of Elena Kagan and Sonia Sotomayor. But alas, he didn't, all right? So let's think about this from a slightly different perspective. I'm crushed that Marty isn't on the court. And I always like to turn to Peanuts to help us out in cases like this. Can you hear me, by the way? Sure. Back there? Okay, good. When thinking about constitutional law, it's important sometimes to turn to Peanuts. There's a wonderful strip that deals with what the two of them did. Well, the two of them, I'll tell you who the second one is in a minute, in a third grade essay contest. They're assigned to write an essay in third grade. And the other person is this guy, Schroeder, who's like Marty in a lot of ways. He's very, very intellectual, and he's very, very deep, and he's very, very logical. And they're assigned papers to write, and Charlie Brown asks Schroeder, what did you write for your paper? And Schroeder says, well, I did a paper on Heidegger's metaphysics. What did you do, Charlie Brown? And Charlie Brown says, I wrote my paper on Our Friend the Beaver. This is an Our Friend the Beaver constitutional talk. You heard Heidegger's metaphysics. This is about, I think, and Marty's quite right about this, this is as much about politics and ideology as it is about strict constitutional theory, and there's no way to get around it. You read the opinions that have been rendered so far, and you do get that impression. To a certain extent, I agree with some of the things that Marty said. Let me beat this point just a little bit more, and then I'll get to a little bit more substantive discussions. Marty is like that guy, okay? Who's that? That's the second Justice John Marshall Harlan, who was really popular at Harvard when Marty and I were both there. Very thoughtful, fairly conservative man in a lot of ways, but believed that constitutional doctrines had in them the correct resolution to problems. I come from a different tradition than that. I think that Marty does, and John Marshall Harlan. Let's be honest, I'm more influenced by that guy. That's Oliver Wendell Holmes Jr. You remember what he said? He said, the life of the logic is not logic. The life of the law is not logic, it's experience. The felt necessities of the time are more important than the syllogism. I think, now Marty and I may disagree about this, but I think that there are others who are following in that tradition as well. There he is, Antonin Scalia, and dare I say it, Clarence Thomas. These are guys thinking about the broader meaning of the Constitution. And I'm not sure you can resolve this particular question thinking only through doctrinal analysis. I wrote a book on this once. It's a fabulous book, if I say so myself. It's out of print, but it approached these problems from that kind of perspective. Still available in used bookstores. One of the things that Marty said, though, struck a wonderful chord. And that chord was the way he beautifully described how the Constitution operates and how constitutional analysis operates and what you think about when you're doing constitutional analysis. He talked about his opportunity theory, that you got to think whenever you're looking at anything, is this an area marked out for particular treatment? Marty didn't mention, though he's quite aware of the argument, the 10th Amendment, okay, established in 1791. A wonderful amendment, okay? The power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. I think actually the folks who framed that amendment had a point to make, and it's still a powerful point today. Intriguingly enough, it's now very much a subject of debate between the two parties. The Republicans like to invoke it, the Democrats do not. Now, Marty's quite right that there's some hypocrisy involved in some of the Republican positions. He's absolutely right about the attempt to federalize the law of products liability. But let's pass away from that and let's ask his question again. What exactly would the Founding Fathers do in this area? What should they do? What would they do? What would they think about? Would they approve of what's in this particular piece of legislation? Well, it's a complex question. I'm not sure there's an easy answer, but there is this concept out there of federalism that seems very important to a lot of people. This idea that the federal government should not be all powerful. This idea that the states ought really to be the primary lawmakers because they are, in fact, the government's closest to the people. Now, it's tough to maintain that argument in this day and age, and let's be honest, since the New Deal, it's been very difficult to maintain this. Let's remember what the ethos of the federal government really is now, and that ethos is, if it moves, regulate it. If it doesn't move, kick it, then regulate it. If that's it, maybe Obamacare makes a certain amount of sense, but there are folks in the Federalist Society and other places who are trying to make us remember that wasn't the scheme that we were supposed to be following. Marty mentioned, quite appropriately, Marshall and Hamilton and Washington. He left out two other guys, Madison and Jefferson. Those were folks who understood this notion of the government's closest to the people being the ones that were the most important. I think they might have some problems with this, and not just problems with the current president. There's some interesting clues out there. Marty, God bless him, has no doubt that the Supreme Court is going to uphold this piece of legislation. I was just informed by one of you before this discussion started that the odds makers are putting it at 3-1, right, that the Supreme Court will throw out the individual mandate. Rather interesting. Why might they do that? Well, there's some clues being thrown out. Here's one of the key clue throwers. That's Justice Kennedy, who most people believe, I think probably correctly, will be the swing vote in this case. What's he said recently in an opinion earlier this year? He said, federalism is more than an exercise in setting the boundary between different institutions of government for their own integrity. State sovereignty is not an end in itself. Rather, federalism, the idea of two separate governments, one with limited powers, secures to citizens the liberties that derive from the diffusion of sovereign power. It might not be a liberty not to buy health insurance, but it is a liberty to preserve the constitutional structure of federalism. That's from Bond versus United States, 2011, and I think it's a hint, the way Kennedy may go here. Let's do one of the outrageous arguments that Marty doesn't like, but that I do a whole lot. If they can do this, what can't they do? Clearly, they can force us to buy fuel-efficient automobiles. You want to drive that? I like my Z4 convertible, thank you very much. Worse, Worse, the same argument, I think, could support forcing us to eat our broccoli and our cauliflower in order to remove us from the roles of sick people and lower the cost of health care. I think that that's not a completely fanciful argument, but let's be, like Marty, intellectually honest here. Marty's right. There are some Commerce Clause precedents that support this. The Wickard versus Filburn case that he beautifully, eloquently, and quite clearly described says, even if you're just growing wheat for your own use or that of your animals, it has an effect on interstate commerce. And the federal government, because all the farmers out there might do the same thing, and the federal government can step in and regulate it. A Supreme Court decision could be written simply citing Wickard versus Filburn and support the individual mandate. Same thing, and I like the way that Marty did it. I won't be as funny as he was, but I like the way he described Gonzalez versus Raich, because he was absolutely right about that. Congress can criminalize the production and use of homegrown cannabis even where the states sanction its use for medical purposes. It ought to be the states that think about what's best for medical purposes, but the federal government can come in and regulate this. If it can do that, maybe there are a few limits. I thought Marty also did a great job suggesting that there are, in fact, some limits to Congress's power. The Gun Free School Zones Act he described absolutely beautifully. This was the first case in 1995 since the New Deal to restrict Congress's power. That was a signal again that the court is thinking about what's going on. Maybe the New Deal did go just a little bit too far. And then, of course, the United States versus Morrison Act, parts of the Violence Against Women Act of 1994 were, in fact, unconstitutional. Marty did a good job describing those. I don't need to go too much further. But they do tell you one thing, these two cases. And I think Marty glosses over this just a little bit. And that one thing is, any theory of the Constitution that you put forward that justifies federal government regulation has to have some limits. You have to be able to draw some lines and say, this goes too far. What I didn't get from Marty was a clarification of what those limits are. Now, what are those limits? And as a matter of fact, the courts haven't really, even those that have thrown out Obamacare, particularly clearly fleshed that out, other than to say very, very general things. One very, very general thing is, if your interpretation of the Constitution does away with the system of dual sovereignty or takes away from the states traditional areas that they've regulated, like healthcare, like insurance, maybe there's something wrong with what you're saying. The 11th Circuit basically said that. Now, for my money, there's a probably somewhat better line to draw, and I thought this guy, Judge Roger Vinson in Florida, drew that line. Marty doesn't like the distinction, but I do. In the Florida case, the Florida District Court case that the 11th Circuit was affirming in part, Vinson said, well, the real test here is the activity-inactivity test. You gotta draw some lines. Maybe this one will do it. In Wickard decided to grow weed. In the Redish case, those ladies in California decided to smoke dope. But this piece of legislation says, if you don't want to buy health insurance, if you don't even think you need it, for the rest of your life, we're going to make you do it. Marty isn't impressed by the fact that that's unprecedented, but I am. It suggests maybe there's a problem here. I like that activity and activity distinction. Watch for it. The Supreme Court may well turn on that. Who knows? We'll see. As I say, he was affirmed on other grounds by the 11th Circuit, but I'm going to finish now and sum up with a very, very simple point. And that simple point is, when the federal government seeks to take over 1/6 of the economy, it eviscerates the 10th Amendment, and it goes too far. And that's all I have to say about it.
Are there questions from the audience?
Judge Sutton is one of the very few judges. He's a conservative Republican. He's one of the few who kind of broke ranks ideologically. And he thought that the activity and activity distinction didn't work very well, and I wonder if you want to respond to that. The other question is more generally, to the extent that your argument rests on the notion that healthcare is not really for the federal government, what do you think about the validity of other federal healthcare legislation, since those might also be challenged as on 10th Amendment grounds?
I'm going to pass this back.
No, you've got your own mic. I think,
Questions for you. Do you think? I read Sutton's opinion. It didn't make all that much sense to me, so I think all I'd say about it is he got it wrong. The other question is a much more difficult one. This individual mandate reaches right into the heart of state regulation. Every single state regulates insurance. Every single state has an insurance commissioner. Every single state has healthcare rules. There may be a line that you draw, and maybe some of the federal statutes that deal with healthcare might be questionable under the same sort of logic. I haven't done that study, but it strikes me that this is a pretty blatant example. And as I think it was Marty who said earlier, I'm just as sure that it's unconstitutional as Marty is that it's constitutional.
Steve, can I just follow up? So the Supreme Court held in the Southwest Underwriters case in 1944 that Congress did have the power to regulate insurance because it substantially affected interstate commerce. Do you think that that's wrong?
I do have a problem with it.
Can I just say something about the 10th Amendment? I didn't mention the 10th Amendment because it really adds nothing to the debate. The 10th Amendment, if you look at the actual words, and I thought conservatives were into strict construction, somehow that's getting lost here. If you look at the words, what it says is powers not granted to the federal government are reserved to the states. So how do you figure out whether something is reserved to the states? You look at whether it's on the checklist. The 10th Amendment, by its own terms, by the four corners of it, is not an enclave. It is simply a restatement of the checklist. It is a political exclamation point that many of the state ratifying conventions wanted to put in. I compare it to the sign that says, no shoes, no shirt, no service, this means you. This means you doesn't really add anything except it's there for purposes of emphasis. So it's a complete circularity to rely on the 10th Amendment. If something is authorized by the Commerce Clause plus necessary and proper, then by the terms of the 10th Amendment, it doesn't violate it. So.
Yeah, I remember this came up this is the second time we've done this dog and pony show, and we're going to do it one more time before we're done. And I remember when Marty said that the 10th Amendment is not part of the enclave theory, I simply replied to him in my best French, au contraire.
And I had no reply to that.
That's right.
You stated that the only Republican candidate you have ever voted for was Abraham Lincoln. Does that mean that in 1904 you would not have voted for Teddy Roosevelt?
Oh, actually, I've been reading some stuff about Teddy Roosevelt that will send your hair on end about what a racist he was. But that's another story. I will admit, I did like Rutherford B. Hayes' beard. It reminded me of the Smith brothers. I might have given in to my emotions and voted for him. Other than that, no, I would not have voted for Teddy Roosevelt. William Jennings Bryan, by the way, is a graduate of this school. And graduates of this school have lost 5 presidential elections between.
A better record than many law schools have played.
Probably. So I would have wanted William Jennings Bryan to be president.
I was a Democrat.
Exactly.
What's the difference between requiring us to buy Social Security and requiring us to buy health insurance?
It's a nice question, Bob. There is one difference between the two of them, and that is the Social Security legislation is grounded in the taxing power, and this piece of legislation is not. That's the only way out of that one I know.
So if they called it a tax, we wouldn't be here arguing this.
Alyssa Henning. one of our better students.
Hi, I have a question for Professor Presser. You mentioned that necessary and proper clause analysis is insufficient. We have to look at the question of actually regulating interstate commerce through the healthcare plan. And then you spoke about the 10th Amendment, but I'm wondering if you could flesh out for me why the healthcare proposal doesn't actually regulate interstate commerce in some way.
That's a fair question. The best I can do is probably what Vincent did, and that is we start with the proposition that there ought to be some limits on the interstate commerce power. That's what the Lopez case tells us. That's what the Morrison case tells us. So then the question becomes, all right, where do you draw those limits? Perhaps somebody who doesn't want to participate in interstate commerce, who takes no action to do it, who sees no need to do it, is in fact outside the realm of interstate commerce. That's that argument. And I just say the 10th Amendment part of that is to remind us that the federal government's powers are limited.
Can I just say, even with my failing eyesight, I can see a clear difference between Lopez and Morrison on the one hand and this case on the other. In Lopez and Morrison, the connection to interstate commerce was attenuated, remote, speculative, mostly question-begging and bootstrapping. Here, the connection to interstate commerce is immediate, obvious, and outcome determinative. Seems to me that's a pretty clear distinction.
Not exactly.
Steve, I'm a little bit puzzled here. It's the claim there have to be some limits on congressional power. Yes. The Commerce Clause does not provide any such clear limits. Therefore, it's the job of judges to invent them out of whole cloth and impose them.
Sounds good.
That's an impressive sounding.
I'm just trying. It seemed to me I was paraphrasing what you said, but maybe I'm mistaken.
No, I mean, I think that the judge's job is in fact to interpret the 10th Amendment, is in fact to interpret the Commerce Clause, and I don't think there's any way that that could be escaped. I mean, if constitutional interpretation imposes any obligations on judges, it seems to me would impose this one.
I can see where you come from if you voted for William Jennings Bryan. I understand your entire philosophy.
You have nailed it.
He had me at cross of gold. What can I say?
Just a question about the taxing power. I guess I'm curious why that isn't in play at all. The individual mandate, while it sounds like this horrific, you'll be forced to jail or something, is at the end going to be enforced by the IRS. It's $700 an individual, about $2,000 for a family. Is it just the word mandate? But it's in the IRS, it's in the U.S. tax code. So I'm just curious why the tax code.
There is an answer to that.
Okay.
I hope I can get it accurately enough for you. Repeatedly, when the bill was before Congress, the president and the defenders of the bill said this individual mandate is not a tax. This piece of legislation doesn't increase taxes. That was what they said, and a couple of the judges, Vincent being one, said, gosh, if that's what they said, then this can't come under the taxing power. When the challenge was made to the legislation, the Solicitor General's office backed off from that and said, no, it's a tax, so it's okay. And a number of judges said, no, you said it wasn't, it isn't.
Just a follow-up. I mean, if the Senate, if like the Senate Commerce Committee, in their specifications on the constitutionality as they saw the bill, had the taxing power as one of the things, would that change the analysis then for the court, or is it just what the president's doing politically?
It's a good question. I think that if it was clearly framed as a tax, and there's another thing about this 900-page statute. There are, in fact, some provisions clearly marked as taxes. This one is not. So that here you've got some fairly clear congressional guidance. If, in fact, it was put under the taxing power by the Senate and House Commerce Committees, I think it'd be very tough to challenge it. But the problem was a political one. You couldn't get them to do that if it was viewed as a tax.
Steve, how do you deal with the doctrine that Congress isn't required to recite the sources of its congressional power when it passes statutes?
I don't think it has any application here.
Come on, you're back in school. Points for participation. Yeah.
What does the lack of a severability clause mean to this legislation and to the case in the court?
Do you want to take that? I have some comments.
Why don't you start and I'll react to
Okay.
yours.
The Vincent, as you may remember, the Florida judge, said this is absolutely essential to the statutory scheme. You can't have the provisions that require that people can't be turned down for pre-existing conditions and some other things without this individual mandate, because really it's a redistributionist measure. The 11th Circuit rejected the severability argument. A Pennsylvania judge bought it partly, severed this and a few other pieces of the statute. It's wildly inconsistent. Seems to me the Supreme Court is going to have to come down clearly on one or the other side on that one.
I find it quite troubling because I'm not sure there really is severability here. I mean, I would not like to see the whole law go if this part goes, but if this part goes, I'm not sure how the law really survives, or at least...
That's your intellectual honesty bothering you again.
Well, I'm actually one of the few people who've actually read the 200-page Court of Appeals decision here.
Well, there are two of us.
Yeah, all right. But the Court of Appeals reversing the severability decision made 2 points. One is that it's one of the, there are lots of problems with the legislation that was passed. One was that the individual penalty maxes out at $650. And so it's not clear that the legislative scheme is going to change very much if you strike down the mandate. The other is specifically the absence of a severability clause, that it's part of the handbook of legislative drafting in Congress that statutes are not to have severability clauses. It says that the drafters don't put them in. If it's in there, it's a mistake. Take it out. We don't put severability clauses in statutes. And so the question is, what's the significance of the fact that the initially introduced law had a severability clause and it was taken out? Doesn't that mean that they meant for it to be non-severable? Actually, it means that the Legislative Drafting Service, which is a very competent group of lawyers, did their jobs.
I would think that after the debacle of the Bankruptcy Act in 1982, where they hadn't put a severability clause in, and because of a relatively peripheral jurisdictional problem, the Supreme Court threw out the entire Bankruptcy Act, turning it into our whole bankruptcy system into Lord of the Flies for several years. I think Congress might have learned its lesson that sometimes you need severability clauses when that's what you intend.
Is the reason that you don't put one in that you don't want to invite parts of it to be severed? Is that the thinking?
The thinking is that in general, it's not the case. That the presumption is that when we pass statutes, that if a part of it is unconstitutional, that it's severable. There isn't a presumption of non-severability. There's a presumption of severability. And so if you're trying to leave that presumption alone, you don't say anything any more than you don't need to put in a clause saying that the United States is on the planet Earth and so forth.
There are some members of Congress I'm not sure about being on the planet Earth. That's a...
Well, Marty, you need to write that specifically into the statute as an exception. Jonathan Enton again.
The Virginia challenge to the health care law rested on a state law that purports to exempt all residents of the state from the individual mandate. I'm from Ohio. We are going to vote on a similar proposed constitutional amendment this year. And I wonder if either of you have views about the significance or the legal significance of any such state laws that purport to exempt their residents from even a big, complicated federal law.
Yeah, we'd probably both agree that it has no validity.
Well, look, if Texas can secede, I suppose anything's possible.
Tanner Ainge.
Professor Redish, if you could respond. I think it's an odd hypothetical, but just to Professor Presser's points about what are the limits and making the government, having the government make us purchase hybrid vehicles or eat our broccoli. What is your response to that?
Yeah, oh, actually, I guess I thought I'd given it, and I've written this. Actually, I wrote it before the Lopez case came out, and it basically would have predicted the Lopez case. The question has to be, if this is interstate commerce, have we basically ended the concept of enumeration of powers? Have we effectively consumed everything? And that's basically what Justice Rehnquist said. So people who say I've never agreed with them, that's actually inaccurate. There was that one time in 1995 that I agreed with part of what he said. If the rationale would apply to everything, if the connection is between A and B is just so remote, so speculative that it's obviously just a bootstrap, then we throw it out. But it's a very broad power, and it's been recognized since the early 1800s as being a very broad power, and it was clearly intended to be a very broad power, and it's always been interpreted as a very broad power.
Since people are here to watch professors fight, and since I've been on the same side as Marty thus far, I can't miss this opportunity. What would you think, Marty, about saying that, as I know that you know, before Article 1, Section 8 came out of the Committee of Detail, they'd been instructed that Congress should have the power to act in cases where the states are separately incompetent. Would it make sense to draw the line where Congress can't set forth any plausible story about why there is some national problem that can't be solved by the states, which probably was the case in Lopez and Morrison, since the overriding purpose of the Constitution is to avoid a state of affairs where there's some problem that nobody can solve, and drawing the line in any other way, for instance, the activity-inactivity distinction, means that there are going to be some national problems that no one can solve, some ways in which the American people are helpless to protect themselves against some problem.
That would have been a plausible way to protect federalism. If the framers had hired a consulting firm, Constitutions Are Us, or something, telling us, please tell us how to preserve federalism. One way they could have done it was to say the federal government can act when and only when there's a collective action problem, that unless it's done nationally, there'll be too many prisoners' dilemmas or whatever. They didn't do that. That was an option. It's not the one they chose. They chose instead to enumerate particular powers, and I don't see how that's a plausible question. The question under the text of the Constitution is, does it fall within this power or doesn't it? I don't see how that question has been deemed relevant in the text.
I have nothing to add to that.
More. Going.
Well, we'll stick around and talk to anybody who wants to debate this.
Thank you very much.